Good afternoon, Judge President Lalezi.
Good afternoon, Chief Justice. Good afternoon, Commissioners.
How are you today?
I'm well, but I was just surprised to open a document in front of me. It's written Mulambo JP. And I asked myself, now, is this the wrong book? Only to find that my section is at the back.
You found the relevant section.
Thank you.
Okay.
Thank you.
All right. Are you ready to start?
Yes, definitely. I've been waiting in the cell for all this time.
Oh yes. So oh, you're in apology.
That holding
actually.
cell, I can tell, is not comfortable. It's
So,
also quite cold.
yeah. Those waits are always anxious. But we do owe you an apology, JP. But you're an old hand at this. You know that it's very difficult to stick to time.
Yes,
in these matters.
Yes.
We do apologize for keeping you waiting. All right. You have 2 degrees that you obtained from the University of Bophuthatswana, BProc and LLB.
That is correct, Chief Justice.
Okay. And you have an additional qualification from UNISA. What is that?
Yeah, that was a certificate in deceased estate practice. It was under the auspices of the Law Society of South Africa and UNISA, and focusing mostly on practical aspect of deceased estate practice.
All right. You started working as a graduate assistant at the university, your alma mater, in 1985.
Yes.
And you were there for 2 years.
Yes, I started as a student assistant, and from there I was appointed a graduate assistant. That, of course, assisted me with some of the financial aspect of my studies.
Yeah. But then you decided you wanted to join the sidebar, become an attorney.
Well, from childhood and from where we come from, there has always been that terminology that you studied to be a Magian. And I thought that was the opportunity. Maybe I should not follow the stream of being an academic.
Yeah. So you did your articles with the state attorney?
That is so, Chief Justice, I had to, because there was some financial assistance at the time. I think it was just quite minimal for us to study. And after that, you are supposed to now to go and work in the government service as a payback. And unless you give them cash money, and I didn't have cash at the time. So I was fortunate to get those articles of clerkship.
Yes. And then you opened your own practice directly thereafter. Quite a brave move, JB.
Yes, obviously I wasn't comfortable where I was at the state attorney because some of the big matters were not exposed to us because of the systems at the time and perhaps even my background. So I thought that it's better to take the risk and open up a practice with a colleague of mine who we studied together.
And one gathers that you ran quite a successful practice.
Well, it depends from which angle one sees it. I succeeded and I got appointed to the bench. But it was a kind of practice where mostly one did not get that kind of commercial work. And the kind of work that we were doing, it was community-based and being part of the mainstream organization, human rights. It was that kind of work that doing those human rights cases. And as I say, it's only soon thereafter then I was appointed to the bench. But post-94, that one would have thought would have been time to try and make money, but never came. We were harvested quite young from the profession onto the bench.
But it was quite critical work you did there, even though you didn't pay.
Definitely.
Yeah. And you practiced for 14 years before ascending to the bench.
Yes, I did, Chief Justice.
All right. Just tell us you've done a lot in the judiciary. It's a long list of positions you've held. So just start when you acted for the first time. When was that?
That was in April 2003 when I was called to act in Kimberley.
And by November, you had been permanently appointed.
Yes,
of that year.
in November, yes.
All right. Then you made your way through various courts in the institution. You've acted as a judge of the labor court, then acted as a judge president in the high court where you are presently stationed. Then had these many intermittent stints in the labor courts, sometimes acting as a deputy judge president, sometimes acting as a judge president.
Yes.
And you started acting in a leadership position in the judiciary. When was it? In 2006 already.
Yes.
In the Northern Cape Division, and then had further stints in the acting capacity, in the leadership capacity in the labor courts, until you became judge president
That is
in the
correct,
Northern
Chief
Cape Division
Justice.
of the High Court. So when did you become judge president in your division?
That was in 2017. I think it's July. Yes.
And even thereafter, you've had occasion to continue working in the labor courts in leadership positions.
After my permanent appointment.
Yes.
Yes. Just a few cases I did there, but then I had to relinquish my position as the deputy judge president of the labor courts. But I could assist from time to time until they appointed an acting deputy judge president, and later they appointed the person in the substantive position.
Yes. So how long would you count your stint as in the leadership position in the labor courts to be? It's a few years
You mean
in the labor courts, quite apart from leading in the high court.
Yes, I think it's about 3 years. 3 years, I suppose.
Yeah. And you've also acted at the Constitutional Court for 4 terms.
For a full term, yes. For a full year, I would say, Chief
Yeah.
Justice.
It's 4 court terms. And you acted at the Supreme Court of Appeal. After my departure, when I had been begging you for the longest time to come to that court when I was still there, what did President Malema promise you that I couldn't give you?
Nothing really, Chief Justice. At the time, I had the time.
Yeah.
I think at some stage when I was called upon by yourself and President Petze, it was when I was already at the Constitutional Court. So as a result, I could not. And even before then, I had just started at the Northern Cape as judge president. There were things challenges that I had to deal with and make sure that everything is running.
Yes. Responsible thing to do. Quite apart from your leadership experience in the judiciary, you've done a few other things, led in a few bodies out there,
Yes.
including the Law Society of Bophuthatswana, of which you became president.
Yes, yes, Chief Justice.
You were involved with the Lawyers for Human Rights, NADEL, a council member of the Northwest Circle of that law society in the northern provinces,
Yes.
and the LSSA.
Yes, Chief Justice.
Are you still involved in those positions? Or at least the one, the one with Solplaat University?
Yes, yes, Chief Justice.
You hold the position of council member in that university?
I'm a council member and council representative on Senate.
Your questionnaire doesn't really say much about what you actually do as a judge and a judge president. If I didn't know, because I work with you, I would think this candidate has a skimpy CV compared to the others. But you play many roles in the heads of court cluster, have done so
Yes.
for a number of years. Can you tell us a bit about the roles you've played in that body?
Yes. You mean after I had become the judge
The
president?
judge president, yes.
I lead the Library Advisory Committee, the Judicial Oversight Committee, and other ad hoc work that is given to us. I'm also involved in the Tools of Trade Committee.
Those are not the only subcommittees in which you sit, to my recollection,
Yes.
JP Tlalisi.
Well, some will be the PEC, and then I participate also in the NEC. And as I say, some are just ad hoc committees that jobs I'm allocated to do from time to time.
Yeah. Right. During your stint at the Constitutional Court, you wrote a few judgments which have earned you the commendation of some of the professional bodies who've talked positively on your candidature, including the South African chapter of the International Association of Women Judges,
Yes.
who speak highly of your sensitivity to the plight of women as evidenced by the judgments you wrote there and elsewhere, including other qualities they mention, put you in a pole position for this position.
Yes.
How many judgments did you write in the Constitutional Court, and how many judgments do you have in all under your belt?
I wrote 4 at the Constitutional Court. I haven't counted the number of judges I wrote. It's
An estimate would
it's
do.
difficult. It's more than 50, I may say, if I become modest about it, Chief Justice.
Yeah. There is a comment made by one of the professional bodies, I think it's the Black Lawyers Association, which says you have not profiled, I'm not sure I understand what it means, you have not profiled yourself sufficiently for this position. And I found that a bit startling thing to say about someone who's been a judge for over 21 years and has written many judgments across a wide gamut of legal issues. What would you say to that comment?
Chief Justice, it's difficult to comment because I do not know what the author had in mind by not profiling myself sufficiently. Whether does that mean I did not disclose some of the good things that I may have done? But by and large, I respect Black Lawyers Association. In my life, I have worked closely with them. I participated in their programs as a practitioner. In fact, my partner was a leader in the Black Lawyers Association, and my office as an attorney used to host their meetings, just that I could not become a member per se, because I held leadership positions in Nadel, and as a result, it will be difficult to duplicate leadership positions on both organizations. So really, as I say, it's quite difficult for me to comment on that, but I respect their views on that, Chief Justice.
Yeah. We are going to give you time, no longer than 30 minutes, to tell us what your understanding is about the role of Deputy Chief Justice and what ideas you have in mind in your fulfillment of the responsibilities that come with that office if you are appointed.
Thank you, Chief Justice and esteemed members of the Commission. Firstly, I must indicate my appreciation for the opportunity given to me by the State President of the Republic of South Africa to make me appear before you. As I understand, the letter to the Chief Justice is as part of his consultation process that he seeks to ascertain the views of the Commission on my and my fellow nominees' suitability to hold the position of Deputy Chief Justice of the Republic. Once again, I thank the Commission for allowing me this opportunity. And I appear before you with a clear understanding that there are many of my judicial colleagues who are equally, if not more, qualified for this position. I never knew that coffee might affect technology. I therefore say to you, I do not claim to be entitled to this position. This is an unsolicited opportunity that is granted to me. When I was approached to make myself available for the position on the bench in 2003, I was hesitant because I believed that it was now time for me to fully concentrate on my practice to make some fortunes. I was then convinced that I had to take forward the pursuit for justice and human rights by taking up a position on the bench. The project was to transform the judiciary to be representative of the South African society and its constitutional imperatives. Since then, I was privileged to serve the people of South Africa in different capacities on the bench. I am therefore one of the few who got this opportunity, not because I have been the best out there, but I guess because of the potential for contribution seen on me or sheer luck. That being the case, Chief Justice, I have always believed in a true and meaningful access to justice for all. It is a natural right of everyone to enjoy access to justice, irrespective of his or her color, creed, or standing in the society. Justice should not be preserved of the rich, educated, and the connected. The poor, the downtrodden, and those in rural areas of our country have an equal right with everyone else to enjoy the rights enshrined in the Constitution. Good work has been done so far to realize this right. I do, however, believe that a lot should and will be done by the judiciary to give meaning to this right. For the people to accept that the Constitution is working for them and what the paper is written on, they must be the beneficiary of its mission, be freed from the shackles of poverty and live a better life. I am aware that access to justice is one of the Chief Justice's priorities. I would as such fit well in her vision. As deputy to her, I would be mindful of the fact that she has already crafted a path for her Chief Justiceship. Mine and my colleagues should comprehend it fully and implement it. It would be wrong to run a parallel program to hers. Anyway, knowing her, she never allowed that to happen. Fortunately, I found her to be an open, consultative, and democratic leader. I now briefly deal with the difficulties that the public face in the courts. The rules, the directives, and procedures in place to prepare and present cases for adjudication should be simple and easily understandable by ordinary members of the society. They should not be costly and unaffordable. Remember, the poor are the most vulnerable members of the society, mostly requiring protection by the law and the courts. This should be the position in all courts, but particularly in the Magistrates' Court, the High Courts, and courts of similar status. The law must serve the people, and not the people serve the law. All the procedures, rules, and precedent that impedes speedy access to justice must be done away with. I know that this would not be an easy task. However, starting will take us somewhere, and the task would be easier as we gain more experience and momentum. For a start, placing the rules board for courts of law under the full control of the judiciary will contribute in addressing this problem. There is only one High Court of South Africa with 9 divisions. The divisions are not independent courts in a federal system of state. It is therefore important, in my view, that practice directives and procedures be standardized for uniformity. We often see practitioners from other provinces who appear in our court requesting that their matters not be heard because some of the overly technical objections have been raised. They would say that in their jurisdiction, the practice is that failure to comply with the practice directive renders the matter to be struck off the roll. They become surprised that we do hear such matters to speed up finality. We should avoid elevating form over substance. I believe in the notion that judgments of the courts must be simple and free from unnecessary legalese or jargon that make them difficult for ordinary litigants and the society as a whole to understand. Although it might come at some cost, it would contribute to access to justice for the judgments of the courts, particularly those setting precedent and or affecting the daily lives of the society, to be translated into all official languages. Litigants will easily understand why they lost or won their cases. Some of the judgments may make good and informative reading for scholars in the rural areas. Communities will be informed of the challenges the country is facing and why their lives are not improving. They will understand how the courts function and how their hard-earned constitutional rights are to be protected. Reading the judgments will contribute to deal with the scourge of crime. The list of simple things can be done is not exhaustive. It will be easier for an independent judiciary to do its roadshows to consult with the communities on their needs. For one to serve as the Deputy Chief Justice, he or she must first be well equipped to serve as a judge of the Constitutional Court. The core function of a judge at all levels of the judiciary is to judge cases. That requires one to be able to understand, comprehend, and resolve difficult and vexed issues of the law. One must have a deep understanding of the Constitution and the human rights enshrined in it. The thinking and reasoning of a justice of the Constitutional Court must give meaning to the aspirations of our forebears by maintaining good jurisprudence, developing and building the good and strong body of jurisprudence of the court. We must not drop the standards because our jurisprudence is the envy of many societies beyond our imaginary borders. I have served a full year as an acting justice of the court from February 2021 to January 2022. I was, during this period, exposed to the environment, the work, and the workings of the court. I have authored some judgments that will assist this commission in formulating a view about my suitability to join the court. I have to confess, though, that a year cannot be enough to provide a full proof of my ability to serve. It does, however, give the sense of the potential one has. The position of Deputy Chief Justice is not an administrative position per se. It is a leadership role, a position not only to the Constitutional Court, but to the entire judiciary. To the court, if appointed, I will be required to provide intellectual leadership, adjudicate in hearings of cases, preside over the hearings in the absence of the Chief Justice, and to ensure that the committees of the courts are active and meet their targets. The question to be asked is, how will I be able to cope if I am not appointed from the ranks of the court? It will, of course, be a challenge. I, however, believe that it is not insurmountable. In my years acting state, I was able to observe the high level of collegiality displayed by the justices of the court. Like all acting justices of the court, I was treated with respect and dignity. They were all willing to assist and guide me whenever required. The Code of Conduct and Judicial Ethics demand of us to respect and treat our leaders with respect whilst maintaining our individual judicial independence. I do know that I will have to work even harder to make it easier for my prospective colleagues if appointed, to reciprocate. My appointment to the position of Deputy Chief Justice would contribute to what the Chief Justice described in her 2022, I think, interview as bringing synergy between the Constitutional Court and other courts, such as the High Courts. The fact that I come from the so-called small division should not be an impediment to one's career development. The Chief Justice reminded us in 2022 that she was based at the Mthatha High Court, which was said to be a small division. She was then called to serve at the Supreme Court of Appeal. Here she is, the rest is history. I'm aware that there are challenges that the Constitutional Court is experiencing. What comes to mind is delays in the release of judgments. These challenges were there when I acted at the court. To me, they have nothing to do with the quality of justices who were appointed by this body to that court. They are without doubt seasoned and well-respected jurists doing their best to carry the court. The volume of work increased exponentially since its jurisdiction was extended to all other matters with the leave of that court. There is a proposal that the Constitution be amended to enable the court to constitute small panels to decide the ever-increasing applications. These proposals are well-founded and must be supported. The use of panels may have its unintended consequences. Care must be taken to ensure that panels do not issue conflicting decisions or depart from existing precedent. Once the parties or mostly practitioners note that the decision is made by only 2 or 3 justices, or in their subjective view, they do not recognize the jurisprudential ability of those justices, they would, as a matter of course, apply for reconsideration. The court might be inundated with baseless applications for reconsideration. My recollection is that the court was deliberately structured by our forebears in such a way that every justice of the court should be part of the decisions of the court as the apex court. This concept was based, among others, on the fact that there is no second bite at the proverbial sherry. The decisions will be attributed to the court and not to the panel. Some justices might have strong views on matters that are not allocated to them. I would venture to suggest that before the decision of the panel is finally issued, it be laid for inspection for a period, say 7 days, for other justices who are not members of the panel to express their views if necessary. As the commissioners are all aware, Section 165, subsection 6 of the Constitution provides that the Chief Justice is the head of the judiciary and exercises responsibility over the establishment and monitoring of norms and standards for the exercise of the judicial functions of all courts. Section 4, subsection 2 of the Superior Courts Act provides that the Deputy Chief Justice must exercise such powers or perform such functions of the Chief Justice in terms of the Act or any other law as the Chief Justice may assign to him to her. Furthermore, in the absence of the Chief Justice or in the office, if the office of the Chief Justice is vacant, the Deputy Chief Justice must exercise the powers or perform the functions of the office of the Chief Justice. This means that a person appointed to the position should at all times be able and available to perform the functions of the Chief Justice. My experience of acting Judge President of the High Court, the Labor and Labor Appeal Court, acting Deputy Judge President of those 2 courts, the Deputy Judge President of the Labor Courts, the Judge President of the Northern Cape Division to date, will enable me to perform such functions that I would be required to perform as delegated by the Chief Justice. I was just worried whether is this my new name. I saw the tag was not reflecting my name, and the people of South Africa were surprised, Chief Justice. My service and holding of leadership positions in professional, academic, and civic organizations and institutions will be of great assistance to me in that role. I have for more than 8 years been part of the leadership of the judiciary. I am aware of the serious challenges that the judiciary at all levels experiences. These range from judicial establishment, infrastructural problems, personnel shortages, insufficient tools of trade for the judiciary, security risks, etc. Some of these challenges were highlighted at the recent judiciary conference held in 2023. Several resolutions were adopted for immediate implementation by the judiciary. The resolutions provide a template for the trajectory that the judiciary should traverse. Chief among the resolutions is the pursuit of a constitutional imperative of an institutionally independent single judiciary. South Africans have recently witnessed the undertaking by the President to ensure that an institutionally independent single judiciary will be achieved. Though this has been a struggle that has been waged by the judiciary and civil society, the decision is welcomed as it is never too late to build a constitutionally compliant judiciary. I believe that with the passing of the Superior Courts Act 2013, ordaining the Chief Justice as head of the entire judiciary, a single judiciary was created. The magistrates' courts, which were before then dealt with as an extension of the public service of the executive arm of the state, were given judicial authority and placed under the fold of the Chief Justice. What is left is to remove the magistracy from the administration of the Department of Justice and be supported by the legitimate administrative support of the judiciary as a whole. I believe that placed within the administrative support of the judiciary, they will benefit from the special focused treatment and not be left to compete for resources with other non-judicial entities. Some of the resolutions of the conference, without discussing them, relate to information communication technology and digitization, court annexed mediation, accountability, judicial code of conduct, norms and standards, remuneration and benefits, devolution of judicial officers' salary and benefits upon death, security, library services, ICT services, and infrastructure and facilities, and the frequency of holding conferences by the judiciary. It is unfortunate that currently, even if the judiciary can decide on its priorities, the budget required, therefore, is not decided by the judiciary. The provision in the Superior Courts Act that the Chief Justice is to be consulted for the compilation of the budget is artificial, to say the least. The judiciary is not given a final say. That is why the Treasury is free to cut the budgets without consultation, as it has done in the past. Those budget cuts hampered the judiciary in meeting its constitutional obligations. The blame was unfortunately laid at the door of the judiciary and not the paymaster. The current budget for judges' administration, as an example, is as follows. The Constitutional Court for goods and services is only allocated 15.25 million, and for purchase of capital expenditure is 3.6 million. For the Supreme Court of Appeal, the allocation for goods and services is 9.6 million, and for capital expenditure, 4.5 million. Now, for all the high courts combined, it is for goods and services, it is 71.8 million, and for capital expenditure is 62.2 million. And for the specialized courts, it is 7.174 million and 3.17 million, respectively. These allocations are not enough, and worse still, are not based on what we may refer to as the judiciary's own priorities. I do not need to be appointed Deputy Chief Justice to support the Chief Justice and the judiciary. I have already pledged my full support to you, Chief Justice, in your project for the judiciary. I believe that if appointed to the position, I will be capable of supporting the Chief Justice and as required. I will do my best to ensure that her vision is achieved. Fortunately, in a short period as Chief Justice, she has been able to persuade the executive to comply with the Constitution by allowing the judiciary as an arm of state to have its full institutional independence. I must commend the Minister of Justice, who, when the matter was raised with her, she gave it her serious, urgent attention. She never thought that full institutional independence will reduce the size of her department and the budget. The road ahead is the most critical one. We have to work as a collective to make the process a success. As leadership of the judiciary, we should fully support the Chief Justice in making sure that the judiciary succeeds and is not in the news for wrong reasons. We should build the judiciary that is responsive to the needs of society, the judiciary that is ethical at all levels, the judiciary that upholds the supremacy of the Constitution and through its judicial work contributes to building a non-racial, non-sexist and prosperous society in which everyone has an equal opportunity to enjoy the freedoms guaranteed in the Constitution. Build a society free of crime, particularly gender-based violence and discrimination. Once fully independent, one of the urgent tasks should be crafting a method of accountability. We will be managing public funds, and we have to account to the people of South Africa as to what we have done with the money they gave to us. Chief Justice, I will end there in the interest of time, and maybe if there are questions relating to some of the issues, I could. I'm trying to save time that this process should not take long. Thank you.
No, thank you very much for that powerful presentation, JP Tlalesi. And I did not acknowledge the critical role you played in respect of the judiciary's endeavors recently. You were part of that small delegation that recently had negotiations with the executive and made a compelling presentation on behalf of the judiciary at that meeting. Would you mind telling us a bit about
Yes.
what you spoke about there? Because it's
I do not mind at all.
I know the minister would not be happy to have those matters rehashed, but it's important to just to keep stoke the fires, keep them burning.
Thank you, Chief Justice. I do not mind at all, Chief Justice, and well, thanks to the minister that we had some discussions in preparation and identify those sticking problems that we had. But the role that I had to play and emphasize was the security at courts. I mean, this is a very, very serious issue that the courts are not safe places, not only for the judiciary, but for the users of the courts. We have seen in recent times in the Western Cape where people were killed or someone was killed within the court building. Now, we had to emphasize that there's an urgent need to ensure that the courts are safe. The infrastructure that is there is quite old, it's not working. The scanners that are there, the detectors are not working, and the services provided by private persons or private companies which are contracted to the Department of Justice. And quite often you find different faces of people who are there. And at times you'll find that, especially towards December, when the contracts come to an end, they don't come to work because they are protesting, they are never paid. And there's always doubt as to whether they will be taken over by the new service provider. So these are serious challenges, and I'm happy that at that meeting, if anything that was discussed there is not secret, the minister in the presidency made it known because of our plea that an urgent assessment of security in all courts should be undertaken. so that when we've got that report, we can see which are flashpoints, which are areas that need urgent attention. And she indicated that state security will soon be doing that. I think that is a very positive step, and I assure South Africans there that this problem that they are all facing with us is being addressed. Thank you, Chief Justice.
Thank you for sharing that with us, JP. I'm going to ask you a question I also asked of the previous candidate. How long would you serve as Deputy Chief Justice if appointed before your retirement?
5 years, Chief Justice. If it's tomorrow, it will be 5 years, 4 months, maybe.
All right.
There's still mileage that I can still build on.
Yeah. One last question for now. You have been head of your own crawl. You've been a leader, unaccountable to accountable to the constitution and your colleagues, of course, but holding a managerial position in your division and everywhere you've worked since 2006. Would it not be a challenge for you to suddenly find yourself working as somebody else's deputy? Now, number two, having to account to somebody else, somebody who's a woman. I'm not going to say the rest of what's on my mind. You know what it is.
I don't see how that can be a challenge, Chief Justice. I mean, at the moment, we are under your leadership. I was at the Constitutional Court, at the SCA, and President Malema was there. She provided leadership. And being a leader in the judiciary, you cannot operate alone. Your own colleagues assist and are part of the leadership, and you give them tasks. As a result, serving under someone else shouldn't be a problem. I am prepared to do what I am called upon to do. I'm not there to represent myself. I'm not there for my ego. I'm there to do what the people of South Africa would want me to perform, irrespective of who is in charge or the leader.
Indeed, Judge President, judging from your enthusiasm for the work which heads of court deal with at their cluster, you have unstintingly thrown your weight, your full weight, in support of the new administration at all times.
Of course.
So I do know that you mean what you say.
Yes. Thank you, Chief Justice.
Colleagues, do you have questions for the candidate? Sorry? Minister, President Malema, then Prof down there.
Thank you very much, Chief Justice.
Yes.
Good afternoon, JP Tlalis.
Good afternoon, Minister.
Thank you very much. I think, let me start with your comments, and I'll lead it to the question as well. In your input, you reflected that access to justice by South Africans, irrespective of their social standing, is important. Yes. And you further indicated that people must be the beneficiaries of the Constitution and it must work for them. You are currently the JP in one of the provinces with high unemployment and poverty levels. If you can share with us, what innovative mechanisms have you put in place as the JP in the province to ensure access to justice by the most vulnerable people in our society, especially in the Northern Cape? Thank you.
Thank you, Minister, for the question. Maybe I need to sketch this background that Northern Cape is a vastly, is the biggest province in the country. I think it's big. If it's not bigger than England, they could be competing for size. And distances we travel are quite long. As an example, to go to Springbok for a circuit court, you have to travel 850 kilometers, single trip. meaning as a judge, you must leave on Saturday morning, sleep over in Appington, and continue on Sunday to arrive there. And some of the areas have got small communities. We always encourage the registrar's office that at all times they should be open to accept people who come in. I often hold meetings with practitioners, leadership of the profession, but in particular the legal aid board, to ensure that they take up matters that the communities in the area might wish they be taken up. Unfortunately, because of our location, we do not have the presence of civil society, unlike in other areas. So we saw the legal aid as playing a critical role in that. I have the office manager in my office who works together with quite an experienced director of court operations. They also are able to listen to what the people are saying, to the complaints of the people and what they need, and they do some form of a referral system. Our wish was to have sort of a pro bono office, firstly in the High Court, in the seat of the High Court, and have that in other courts, but it's not. It didn't come to fruition because we don't have such many practitioners and members of the community. One other disadvantage is that we have a new university. Unfortunately, it does not have a school of law. If the school of law was there, there would be a university law clinic, which I have worked in before, where I came from, and that will also assist to take up issues for people. But by and large, for now, we just have an open door policy. We say anybody who's got a problem, whenever we address the gatherings, they should come to the court. Thank you.
Thank you, JP. Maybe just to follow up on that one. I think for the last 5 years, my district was DR, and I understand the traveling that you are talking about. I was the champion. What we call district champions as the executive. So I understand the distance that you're talking about of judicial officers having to travel, because within that area, just to travel from one municipality to the other, you're literally traveling more than 150 k's, or one community to the other.
Yes.
And following up that, I understand the issue of traveling of the. Okay, I can see you are battling to hear me. Let me bring the mic closer to me.
Thank you.
So I understand the traveling of the judicial, but I would want to understand, how do we ensure, because majority of the people that we serve in our communities, and looking at your profile, I think you'd understand very well in terms of human rights and access to justice for those vulnerable, and majority in our communities will be women. How and your championing of women, that's why I'm coming back to that one. I'll just include. How the issue of them being able to access, because if we look at where the courts are still a bit far apart, what creative mechanisms have you been able to? We see in other areas, for example, the issues around where innovation, they would designate a particular area, either a community hall because of interest or all those things. Have you been able to do that for Northern Cape in light of those challenges that exist? Or if not, what has been the inhibitors in that particular area of you being able to do that?
Yes. We have done that, Minister. I know that, I recall that I have sat in Calvinia at the time, even at the town hall, to do cases there, and the members of the community were able to attend. If we see that this case attracts more people from a particular community, we do travel to there and set up a court there. You know, you spoke about the distances. If you take Poor Father, they have to attend the circuit court in Appington, which is a big challenge. Witnesses and accused persons, they have to wake up very early in the morning and hike to Appington. some would get transport, say 12 o'clock, and the court has already started. And upon arrival, the case may be postponed, or you cannot sit for the whole day. They have to travel back. And some have evenly pleaded that a judge should issue an order that they be accommodated at a police station, which is something quite difficult. But I say we do move from places to place depending on the interest that the community have in a particular case, so that we eliminate this traveling from Springbok, Aggeneys, and other places. We do sit in those. But on something bigger that one thinks of, once we attain our judicial independence, our administrative wing, I would venture to suggest that we should have paralegals who are going to work within. Some may be law students who are unemployed, to be able to be the contact between the administrative component of the court with the communities, and hold workshop with them to try and conscientize of their rights, see if what the kind of problems that they have, and maybe refer them to various institutions that can assist. But that would be on a long term, once we get what we have pleaded for. But for now, we do look at the interest in a particular case, we then move to those places. I know of instances where some judges have had to give some people money so that they can accommodate the witnesses to travel, because it's so difficult at times. Thank you, Minister.
Thank you very much, CJ. Thank you, Judge Tlalit.
Thank you.
Thank you very much, CJ. Good afternoon, JP Tlaletsi.
Good afternoon, President.
How are you?
I'm well. So far.
Let's hope it stays that way.
Please.
JP, in response to the CJ's question about your convictions about serving under a female Chief Justice, you alluded to the fact that you acted at the Supreme Court of Appeal during my tenure in that court. So I thought I should just confirm that yes, you did act in that court, and that when I invited you, you readily agreed, which I found quite gracious of you, given the fact that you are a leader in your own court.
Yes.
And also just to attest to the fact that at no stage during your acting stint did I get a feeling that you have any misgivings about serving in a court that is led by a woman.
Yes.
It was actually a pleasure to have you as a member of our court. That
Yes.
said, JP, you serve in the heads of court cluster. You have been a JP for quite a while. You were part of the delegation that appeared before the president and members of the executive. So you are well aware of the issues that are facing the judiciary. There are a number of them. You alluded to some of them in your presentation. Human capital issues in relation to judicial appointments, in relation to support staff, in relation to tools of trade, and in relation to infrastructure, amongst others. If you were to be appointed as the Deputy Chief Justice, what advice would you give to the Chief Justice in terms of prioritizing these competing priorities? Which one would be a priority for you and why? Thank you.
Thank you. Thank you, President. I must indicate that prioritization of this is not an easy thing, because they are all urgent as a whole, and they need serious attention. But the most important one I would venture to suggest is the capacitation of the courts. Our main function is to judge cases. And it's troubling to see that, starting with the Supreme Court of Appeal, you have such fewer researchers supporting the judiciary. That will be one of the most urgent needs that I would say it should be met. And it should not only be that, even in the high courts, let's build up the capacity of researchers so that they should support the judges. And in that way, you will eliminate unnecessary appeals that will go to the SCA and take time, of the judges of the Supreme Court of Appeal to adjudicate over those things. Security also is important. The safety of judges is important. I also made an example that, if you read the amendments to the minimum legislation, to kill a police officer is a serious crime, is identified, but I have not seen any similar provision relating to a judicial officer that there's a prescribed minimum sentence of life, unless there are substantial and compelling circumstances. So security is important, and it's not only limited to the judiciary, but also to the customers of the court. After security, in that order, I will look at general court infrastructure. In most, maintenance to start with. I mean, these courts, we've got new courts, but we get reports that they are already leaking. They have problems with those courts, and they have been at some stages condemned by the Department of Labor that they are not safe working places. Have a designated budget to deal with the court infrastructure. If you go to areas where the circuit court sits, I will refer to my province where I experienced these problems. There used to be a stage where I was made aware that a court was sitting at a police station, and it was the biggest concern, and we had to stop it. And we had to temporarily move that court from the police station and move it to the municipal offices, because that reflected badly on the independence of the magistrates that were dealing with those cases. So some courts are so small, it's difficult to expand them. Maybe newer courts will be needed because they were never intended to serve the number of people that now are attending to the courts for justice services. Those, in my view, would be the three most critical issues that I would attend to.
Thank you very much for that comprehensive response, JP. Thanks, CJ.
Thank you, President.
Thank you, President. Thank you, JP. Professor Marumachai.
Thank you very much, CJ. Good afternoon, JP.
Good afternoon, Professor.
I have I have two questions for you. The first one relates to the progressive judgment, I think, that you wrote when you were in the Constitutional Court, the Women's Legal Center Trust, that dealt with Muslim marriages.
Yes.
Yes. And that judgment was so critical because we have a very weird situation in South Africa where certain types from certain cultures, people from certain cultures and traditions, marriages are actually regulated by statute, whereas there is a sector in our community where their marriages are not regulated by statute. And of course, obviously, the South African Law Reform Commission has undertaken a process of trying to deal with that. And the Department of Home Affairs also undertook a separate process that deals with that. So we have that challenge in South Africa. But in this judgment, in paragraph 55.
Paragraph?
55.
Yes.
You identified the issue of choice, that despite the fact that a woman chooses to marry in terms of Sharia law or Muslim law, that doesn't entitle her of the economic and social protection that is needed in terms of the Constitution. The issue of choice has been very central in most of the family law / private law judgments of the Constitutional Court, and the nuances of choice. Is it a real choice? Is it an imposed choice? What is your view in relation to the arguments that women enter into certain marriages by choice. And I want you to answer that having regard to the economic power that men generally have when they enter into an institution of marriage.
Thank you, Professor. I think I made a finding that that's not real choice, really. They are left with no choice but just to comply with the instruction as to we enter into this kind of marriage, take it or leave it or whatever. But even if they are in that position, women in particular, economically they are not in control. Mostly in this kind of marriages, the husband is the one who seems to be owning everything that the couple has worked for. And in case there's a divorce, because of, well, let me not call it divorce, a separation, the woman is left without anything. At times she might be left with children without anything. Those children are unable to access maintenance through the formal legislation that has been provided. So economically, the women in those kind of relationships are disadvantaged. And their interest and the interest of their children are not advanced. So as I say, I don't see that really as a choice, because I don't think any woman would ever choose to live under those stringent, horrific conditions. Horrific in the sense that she will come out being a loser at the end, and she does not have control and security that that marriage is going to last long. Religion is encouraged, because now one must tread very carefully between those two. They remain, well, there was that argument, Professor, if I may just make a point that, which is related to that choice, that those who are questioning that relationship, they are modernists. And being modernists, they have that choice also to not enter into those kind of marriages. Also, I don't see the sense of that. It's not being modern. It's to try and ensure the security in the marriage and the economic rights that the woman would have together with the children.
Thank you, JP. And the issue of choice is problematic. I mean, from the Banyo case and the case that came up. I had a different question for you, but you said something that led me to the question I'm going to ask you. I'm abandoning the one that I originally wanted to ask you.
I caused trouble for myself.
You spoke about the rules board being placed under the judiciary. And I've been trying to study the different rules for the different courts. You look at the magistrate court rules, you look at the uniform rules of court, the rules of the Supreme Court of Appeal, and the rules of the Constitutional Court. Well, there are many challenges there, but I just want to, because of time, to point you to a specific issue, leave to appeal. When one looks at Uniform Rule 49, how you actually ask for leave to appeal, and then you look at Rule 8 of the Supreme Court of Appeal, that deals with Rule 6 of the Supreme Court of Appeal, that deals with special leave to appeal. And you look at Rule 19 and 20 of the Constitutional Code, that deals with, well, 19 deals with leave to appeal, 20 deals with appeal itself. When one looks at the process of appeal, I know maybe you may not have thought about it the way I'm going to ask you, but I just need your general view on it. It seems to me that the rules of certain courts makes it so difficult. I'm not sure if the difficulty is the word, but a little bit harder for litigants to the process of appeal. For instance, when you go to the Supreme Court of Appeal, you have to certify a judgment, you have to do certain copies, number of copies. But when you go to the Constitutional Court, there is an email where you can just send the application for leave to appeal. Obviously, leave, you'll have to send other copies and stuff. How can we streamline different rules for different courts to make sure that litigating in those courts, it becomes easier for litigants, as opposed to easier for firms that might have financial resources to make copies and all those kind of things.
Yes. I take it, Prof, you're not referring to the substantive process, but
No,
merely the procedural aspect.
merely the procedural aspect, yes.
Yes, yes. I think digitization would be the answer. If at all levels, the records in particular are digitized, it would be easier for the levels of the judiciary to access those records. We'll be doing away with paper that will need to be certified or whatever. But what we will know that since the computer system and the software are approved by the judiciary and certified as an official recording system for the courts, all levels of the judiciary will be able to rely on those records. And it should be easy, like we propose that in the Constitutional Court, you can write a letter and then the others can follow. But we must also be mindful of the fact that even though the procedural aspect might differ, there would be certain consideration that if you are from magistrate and you make an appeal there, what kind of matters are being dealt at that level? Same would apply to the High Court and the Supreme Court of Appeal. So the type and nature, the seriousness, complexity of the matter will also play a role. But in my presentation, I said it would benefit the country if all these procedures are streamlined, so that access to justice should be made easier and less cost-effective.
Very much, JP. Thank you, CJ.
Thank you, Chief Justice. Good afternoon, JP.
Good afternoon, Commissioner.
I think you do know that this position will be a second in command if the president decides to choose you. And my question relates to the attacks on the judiciary. I mean, a lot of people are complaining that the Constitution is not working for them, and the judges are biased. What do you think you could do, actually, as a DJP, to make sure that people understand the judgments and have confidence in our Constitution?
Yes. Thank you, Commissioner Lepu. The answer I would give would build on my presentation of the translation of all court judgments into official languages. And then the communication department of the judiciary should be strengthened and capacitated so that it can deal with the complaints that are made against the judiciary. I mentioned that as the judiciary, soon after our independence, we've got to sit down and think of roadshows where we go to communities and conscientize them of their rights, because most of the time it's lack of information or misinformation. And parties that are dissatisfied are the ones at times that are causing this problem of misinforming people. But I think we owe it to the South African people to educate them about the Constitution, to show that there's nothing, I would say, with the Constitution. The only problem is how is it implemented by the three arms of the state, because they have to play a role in implementing it, and show them of their rights and what they need to do. if there's a problem, and make it easier for them to bring up their complaints if there are any. So that department will obviate the problem of the judges or the chief justice being named, and then she has to respond, which I don't think it will be an advisable thing to do personally. But have that designated department to deal with that. We have made some progress in that. The department is there, the unit is there, is being capacitated from time to time, and we do have a judge that is responsible for that, and that will be able to address some of the problems. So I hope I have covered the commissioner's concern. Thank you.
Okay, thank you,
Could
Chief
I
Justice.
follow up on this, Chief Justice? Mr. JP, I mean, firstly, I'm not sure about this translation of all judgments and then
Yes.
visits by all of the judges to every part of this country. I mean, the minister is telling us there's no money even to pay for new positions. Now, we must now find money, well, the government must find money for a project of translating judgments, and then it must also find money to transport judges around and having workshops with communities, etc., etc. So anyway, I'm just not sure if you've thought seriously about that proposal in the light of the constraints that the judiciary is currently facing and the priorities it should be having to deliver justice. And I'm not even sure what the object of these visits are going to be. But that's not why I asked to make a follow-up. I wanted to make a follow-up on a substantive issue. The question by Commissioner Matolo is a very crucial one, which is that we have an apparently progressive constitution, but we have the most unequal society in the world by the Gini coefficient, according to the studies of the World Bank in 2018 and 2021. Now, the function of the judiciary is to interpret the constitution. That is the primary function, and to interpret the law and, where appropriate, to develop the law. But their job is to interpret the constitution. You've said that there is nothing wrong with the constitution. That's fine. Even if there was something wrong, there's nothing we can do. We must live with the constitution we have. But I want to question your premise that there is also nothing wrong with the interpretation of the constitution. Last week, 2 weeks ago, the professor from Stellenbosch, Sandra Liebenberg, gave a speech at the 30th anniversary of the Constitution, in which she questioned whether or not the Grootboom standard is still an appropriate response to the socio-economic crisis that South Africa faces. This is a 25-year-old standard. What is your view on whether the Grootboom standard is still relevant to meet the crisis of inequality that South Africa faces?
Yes. I don't know if I should deal with the initial comment. My answer to that is quite short. I said, once we attain our judicial institutional independence, we could pay attention to ensuring that as the judiciary, we conscientize people of their rights. At the moment, it's not within our own priorities. That will be for the executive to do. But that one is on what I said was on a long-term basis. I agree. The interpretation of the Constitution is the one that might create problems, and at times it does create problems. The Grootboom standard, I would say it remains relevant provided that it is being developed. We need to allow the executive to make sufficient provision to realize those socio-economic rights. It's quite difficult because now that will depend on the executive self. But as we interpret the Constitution, we should nudge the executive towards realizing and implementing those rights.
I don't think anyone disagrees with that. I mean, the Grootboom standard
Sorry,
essentially.
I missed.
I'm saying I don't think anyone disagrees with that, but I'm questioning the content of the Grootboom standard, which is based on this idea of reasonableness.
Yes.
That what the court does is through judicial review to assess the reasonableness of the measures taken by the legislature to fulfill the rights in Section 26 and Section 27. Now, the critique specifically is that that standard is inadequate because it's inexact. And the Constitutional Court had rejected in 2000 the minimum core. But it needs to move beyond reasonableness and to give something tangible. And what is the correct way of doing that? And that's the theoretical discussion that Professor Liebenberg was putting forward.
Yes.
Using examples like Daniels versus Scribante, saying, for instance, the content of the right to housing includes habitability of the dwelling.
Yes.
And then a more recent case delivered by the Constitutional Court says the content of the right to housing includes proximity to places of work or to economic opportunities, right? So which means one is moving beyond reasonableness.
Yes.
Because it's an empty standard that does not concretely realize the object behind Section 26 and Section 27. Now, you are going to come in as an intellectual leader of the court, in fact, the second most important office in the country. So I want to understand your theoretical exposition to the inadequacies of the Grootboom standard.
Yes. As I say, Commissioner Mukatobi, we need to develop that standard further. And I appreciate the steps that have been taken up to date to develop it and to make it more realizable. And one will have to think of a creative way of ensuring that sufficient resources are employed to enforce that standard. I can't just think of a particular example now, but as I say, what is provided should be something that is acceptable to the communities. It should be something that will benefit the community. It should not just be a hollow or a shell that is being provided and say that this is what we can afford, this is what is reasonable. I would suggest that we'll have to do more to ensure that it meets the modern and current standards.
But do you have any specific ideas around the development of the Grootboom standard on a normative basis? This is about how to theorize the socio-economic rights in section. This is the biggest bulk of the work you have to do as a judge of the Constitutional Court, is to tell us the meaning of Section 26 and Section 27. So how do you think the standard can be taken forward, if at all? I mean, no one questions what you are saying about the community benefiting from the Constitution, but your job is primarily to interpret the Constitution using a theoretical lens of some sort, and you've got a conservative standard that says no minimum core, and then you've got the progressive realization standard that says reasonableness. But is there anything missing from this interpretation? But I think you've probably said as much as you could.
Well.
Commissioner Shabangumdawe? I'm sorry, did I cut you short?
No, you did not, Chief Justice.
All right.
Thank you, CJ. Good afternoon, JP.
Yes, Commissioner.
JP, you will agree with me that we still have not reached a full
If you could
transformation.
speak closer to the mic, please.
Can you hear me now?
I do, yes.
Okay, thank you. I was saying you will agree with me that we still haven't reached a full transformation of judiciary, in particular in gender.
In gender?
Yes.
Okay.
In assisting to achieve full transformation, what contributions have you made? And going forward, what plans do you have to achieve transformation of judiciary in gender?
Yes. To achieve gender transformation, it shouldn't start at the courts. I believe that it will start with the education from the universities. We were quite aware that in most universities, women outnumber men, but we do not know what happens to them after completing their studies. So it will be important that it be made easier for them to join the profession. And once they are in the profession, they receive training that will prepare them to be able to move forward in building up a pool from which judges can be appointed to continue with the project of transformation. They must be given opportunities through the briefing patterns by the attorneys, business, government, and other institutions that have the capacity to brief them. They should be given good opportunities to act in the courts so that it should be easy for them to settle. The conditions should be made easier for them to be able to survive, if I may use that word, because in addition to doing judicial work, they would have other responsibilities that they have to cater. So there has to be reasonable accommodation to ensure that these do not impede their progression into the profession. Leadership positions, they should also be appointed to those positions. We are already in a good start, and then we should keep the momentum. Thank you, Commissioner.
Thank you, JP. I just wanted to hear your contribution towards that. I hear you're explaining what is it that is supposed to be done, but your contribution as a judge president of the Northern Cape High Court, any contribution that you have made to make sure that transformation of children, in particular to women, do you have plans for that?
Yes, I have already started. I have been giving women opportunities and to act. And if you look, we have appointed recently a woman who has joined our ranks. Being a small division, we've got 3 males and 4 women on our bench. So I will continue from time to time, request the minister to appoint women, and we are giving them those opportunities. And where there's a need to have discussions with them, we find out, because I've had meetings with the bar and say, it looks like women do not stay as members of that bar. They've had their challenges, and I asked upon the leadership there to make sure that they make it possible and conditions conducive for women to be part of that. And that is from where the pool from which we can get women onto the bench. We have reached our final quota, and wherever there are permanent appointments, like it has happened in the past, where we had many women trained in the Northern Cape, they were able to take up positions at other divisions. So that program has been working, it continues to remain part of the plan. Thank you.
JP. Thanks, CJ.
Commissioner Moiman?
Thank you, CJ. Good afternoon, Judge President Tlalete.
Good afternoon, Commissioner Mima.
Just one question from my side, which relates to the access to justice. The same that I raised with JP Mlambo. The court system, which is currently in existence, largely reflects the pre-democratic apartheid system. And this, in a sense, means that the legacy of colonialism and apartheid continues to plague South Africa with spatial injustice, and which impede on access to justice. In your vision, you did make reference to the challenges that either the accused or witnesses are facing when they must travel from or further to Uppington. Now, I want to get your views or your contribution to the recommendation by Deputy Justice Mosenege's Committee on Rationalization. The proposal for the Northern Cape is that we should retain the Northern Cape Division of High Court in Kimberley, and that a new local seat should be established in Uppington. So I want to get your views or your contribution to this recommendation to the Ministers' Committee. Whether are you of the view that this is an ideal situation, or is this a desirable situation given the constraints around the resources? What will be your ideal situation? Will your ideal situation be to have this local seats in 5 major towns of Northern Cape or not? Thank you.
Yes. Thank you, Commissioner Mimang. That recommendation came as a result of my contribution when I made a presentation to the Rationalization Committee that we need that local division in Uppington to cater for now to cater for areas like Springbok and up to Port Nolloth. But this has been a moving target. Years and years back, we were told by the Department of Justice then that they have agreed with JP Khomu then that division be established. However, they kept on saying, we have identified the site, and then the site might not be suitable. We will upgrade the Uppington Magistrates Court. But only to discover, after I had taken over, that there was nothing on paper except for some few letters which were written. There was hardly a project that was even registered to start working on that project. We started pushing and promises were made, unfortunately. I support the establishment of the local division there, and that local division can spread towards other far-flung areas like Port Nolloth and even Springbok, because having everybody to come to from those areas to come to Uppington will only remove the distance between Uppington and Kimberley, but there was still a long road to travel between those towns. I support it, and I wish it could be one of those things that could be sped up and not wait until the entire rationalization report is being implemented. It could be having its own other challenges, but if this one can be given priority, I would appreciate that. And then we can agree on the number of judges that we would need for that. Thank you, Commissioner.
Thank you, JP. Thank you, CJ.
Commissioner Mangena.
Thank you, CJ. Good afternoon, JP Tlaleti.
Oh, good afternoon, Commissioner.
In your opening, when you shared the vision, you said that we must not drop standards because our jurisprudence is the envy of many other countries. Did I capture you correctly?
You definitely did.
Yes. And with this statement, I would want to assume that you share the view that we've got the best constitution in the world, acclaimed constitution.
I don't know, should it be a dialogue or what?
No,
Through you, Chief Justice.
No, don't answer.
Oh, okay.
But with that said, do you think that the people of South Africa share the same view that the Constitution had been adequately used to advance social and economic inclusivity as envisaged by the Constitution?
Yeah. Commissioner, again, you make it difficult for me if you say the people of South Africa. I mean, you've got different classes of people in South Africa. There are those who will tell you that it's working. Maybe it is the connected, it is those who are rich or those who have won cases. There are those that will say it's not working, the Constitution. And whether it is actually the Constitution that is the one that is questioned in some of the remarks that have been made is something that one should carefully consider. Because everything now, if it happens, even if it says another arm of state, they will tell you that, no, you see this Constitution. Some say we want corporal punishment, we have lost control of our children. Is this Constitution? So it's difficult to say the people of South Africa has lost faith in the Constitution. It depends from which direction do you approach it. The Constitution is there, it's working. It may not reach everybody as one would have expected and would love it to do so. But it's our wish that it should benefit everybody. And it's important for the state to put up resources to make sure that all these aspirations of the Constitution, the provisions, benefits the public. I'm not sure whether I've managed to.
No, you did.
Thank you.
My second and last question
Well,
relates to the question.
CJ, just a follow-up on that one.
Yes.
JP,
Yes,
in your own opinion, not a generalized view, has this constitution that is celebrated all over the world achieved that which we went into exile for, prison, people got killed, or it is just praise for just being praised, but has not achieved what its original intention? Let's take, for instance, the land question. Let's take, for instance, the economic equalities in South Africa. Let's take, for instance, gender equalities. You're taking on that matter before. Has this constitution achieved all of those things, in your opinion, that we wished for, especially as the oppressed nations? Because it can only be or be celebrated as a good constitution if the oppressor stands to benefit out of it. Thanks.
Thank you, Commissioner.
Not the oppressor, the oppressed.
Yes, I was, okay, now I understand you, Commissioner Malema. Surely it's a work in progress. We wish, all of us, that the society that we aspired for when this constitution was founded should fully and comprehensively and to the satisfaction of everybody meet those demands, those needs actually. But unfortunately, there are those pockets which still need to be attended to. It's said that people died for this constitution. That is a system that we had to deal with at the time. But we should not lose hope and blame the constitution. It is the people who must implement the constitution that makes sure that it meets those requirements. As I said, some look at it subjectively and look at their own personal circumstances and say it did not work for me. There are those that would say it has worked for me. But by and large, there's kind of society that the constitution is aspiring for. We are on track to achieve it we need to ensure that we fully implement it and achieve what we need to. There will always be resistance, obviously. Not everybody will agree. And now that brings me to the courts. They should play a meaningful role to ensure that the spirit and letter of the Constitution is implemented to benefit those aggrieved. Thank you.
Commissioner Malema was able to extract an answer out of you.
No, Commissioner, it's not fair. It's not fair to say that to me with greatest respect to you. If I gave an answer that you did not like, maybe you should say so, then I can answer it.
No, you were more elaborate when you answered him than when you answered me.
Because he gave specifics, you see, he
yes.
said this and that and that and that, and I indicated to you, it's such a general question that I need to deal with.
Yes, and no offense was meant by that.
Yeah,
but here's my second question.
Yes.
It's in relation to the question that you were asked by Professor here.
Yes.
Regarding the choice that women in particular are set to be able to make when they get into marriage. Now, I'm one person who believe that people, including women, are able to make their own choices, right, on issues of life, including a choice of a marriage or a type of marriage that they want to enter into, because that is a contract. Now, I want to hear your comment in relation to the principle that says agreements have got to be kept, the pacta sunt servanda principle. Do you think that it is a principle that can also be applied in relation to a marriage as a legal contract?
I think if we were to follow that, heavens might fall and say what's happening. Because, Commissioner, you started by saying women are able to make choices. I fully support and agree. But here we are speaking of a special environment where that choice that they might make, it's not really a choice, because circumstances and the environment is such that she's forced into a particular corner just to agree. And if you come up with this commercial principle that agreements must be given effect to and must be binding, you will be disadvantaging them all, because we don't have equal power relations in that kind of an arrangement. And this regulates family lives. It will be difficult in a family setting to say we have agreed on this is how we should go. I don't think it will apply. I don't support it in a marriage situation, because a contract of marriage, it's about status. Now, if you come up with that and say you sold away your status by agreeing to this agreement, definitely it won't work. I don't know how I can express it better than I'm saying. Thank you.
No, thank you. Or would you be comfortable if it's a situation that can be dealt with on a case-by-case basis? Is it a general statement that, is it correct as a general statement that women are not able to make choice in relation to issues of marriage? No. Or it's something that can be dealt with on a case-by-case basis?
We are not saying women, oh, thank you. We are not saying women are not able to make choices. They do. And they have the capacity. What we are saying is certain types of situations are such that they are forced into certain decisions that under normal circumstances, they would not. Let me give you an example in our communities. Up to now, you still have a difficulty, and I experienced this as a practicing attorney, to say, look, if you decide to get married, you've got a choice to be in community of property or out of community of property. But the society and the spouse will say, hey, you know, I can't agree to that because my people, my parents or other people or my prospective husband's parents would say, you are not committed to that marriage. In Setswana, they say, so that you enter only with one leg so that you can keep the other door open. And you'll find that the poor women are forced into the marriage, in a marriage regime that they would not, had it been their own independent, uninhibited decision, they would not enter into. And they only realize later, when things become sour, that their proprietary rights were compromised by that kind of marriage relationship. But let me emphasize, women have the capacity and they do make meaningful and good decisions.
Thank you, CJ. Follow up, CJ.
Yes.
Thank you very much, CJ. Thank you very much, JP. I think the discussion that we have just had with Mr. Mangena is very interesting one. The Constitutional Court has dealt with how we should understand contracts in our modern day society. And there are judgments from the Supreme Court of Appeal which appear to be contradictory to what the Constitutional Court has said in terms of the role of a contract generally and how we can infuse constitutional principles. That debate it's there. Whether or not one agrees with the approach of the Constitutional Court, let's park that aside. Now, if we take the core contractual principles and we translate them into the contract of marriage, can we really say that a contract should be understood in the abstract terms in which a marriage contract should be understood in a abstract terms in which a commercial agreement is generally understood? When one looks at how the Divorce Act and all the other acts provide certain remedies that assist the courts to come up with certain protections for women. Like, for instance, Section 7, Subsection 3 deals with redistribution. Section 9 of the Divorce Act deals with forfeiture of patrimonial benefits. So when one looks at those kind of remedies, can we really say that, yes, you contracted in community of property, let us just say the consequences of community of property must apply to you as strictly as one would understand in the contract sense? How can we deal with that aspect?
Thank you, Professor. In that situation, obviously it will depend how the case is formulated by the parties. But I'll be open to see and hear what has been happening in that kind of a relationship. And not strictly apply that law of contract, because here we are dealing with status of people who have been living together. And so it's possible to infuse the constitutional principles when you resolve that problem and consider everything. Strictly, when you come up with the contractual arrangement, say it's out of community of property, you get nothing. You've got situations where men bought everything in their names and nothing in the name of the husband or of the wife. And now how do you protect her? You have to go behind and look as to how these people live their lives, what contribution. And contribution can not only be monetary contribution, but support between spouses, and decide that issue, approaching it on that basis.
And that's why the redistribution remedy becomes important.
Yes.
Yes. Thank you very much,
One of the
CJ.
conditions.
Commissioner Lefanyana.
Chief Justice, thank you so much. Good afternoon, JP.
Good afternoon, Commissioner.
Look, I'm going back to the question that was asked by the four commissioners, and it emanates from the dictum that you made here when you were given 30 minutes to present your vision. The English translation that the law must serve the people, it was said by yourself. And then, honorable members, the commissioners are asking you question whether the South African Constitution in its current form is adequate, or whether there are deficiencies in the interpretation of the Constitution or statute in our judgments. So within that prism, or using that dictum which you have made here, the law must serve the people, are you convinced that in its current form our Constitution is adequate? Or are there weaknesses in interpretation of statute by our courts? What is your view on that matter?
Yes.
Vis-a-vis, the law must serve the people.
Yes.
Yes.
Thank you, Commissioner. I would not rush to say the Constitution is insufficient. As lawyers, as the courts, I propose we must interpret the Constitution in such a way that it addresses all these problems that the society is facing. And that is the role that the Constitution should play. The provisions thereof are there to assist, and one can find a solution in that. I can't think of a situation where I would say it would not be catered for by the Constitution to the satisfaction. If you want to attain justice, if you want to attain redress, I would say it can play that role. It should be interpreted. The only problem is the interpretation in most of the time. The issue of the translation of judgments, which are important and run our daily lives, I was basing it on the fact that we should make provision for that. The technology has developed such that it can assist in doing that, rather than not doing anything. There should be a starting point, and as we move along, we might attain that. And that will then deal with most of the problems that people may doubt the Constitution. I like the idea that we have the Constitution, we have to make do and make what we can achieve with it as it stands.
Maybe as a follow-up, Chief Justice,
Yes.
Given that inequality and poverty perpetuate, against what you have said, that the law must serve the people, do you see the law saving the people?
Yeah, Commissioner.
Against the background of widening poverty and deepening inequality, is the law saving the people? That statement was made by yourself. The law must serve the people.
Yes. Every effort must be taken to ensure that the laws, that dream is attained. As I say, training and have a paradigm shift. When we look at disputes that we need to resolve, always keep the constitutional principles in mind and make sure that we decide the cases along that lines. There will be cases where there have been failures, but those mainly would have been due to to failure to properly interpret the Constitution. So it's difficult to generalize, as I say, that it's not serving the people. That will be throwing the baby with the bathwater.
Let me ask the last question. It's not related to what I was asking.
Thank you.
The last question would be that in your presentation, you made a commitment to support the vision of the Chief Justice and to do your all best to ensure that the South African judiciary succeeds. If, for instance, the Chief Justice has outlined her priorities, what are the two priorities that she has outlined which you would choose, and in what way will you support those priorities? Just two of the priorities that she might have outlined.
Yes.
Which any two of those priorities that she might have outlined. You can choose any two. Yes. And explain how you will support her in that regard. Thank you.
Yes, first, access to justice. I know it's close to her heart, and I'm equally supportive of access to justice. And whatever we do, and she calls us upon to do, one should work towards attaining that goal. Institutional independence of the judiciary is one of her priorities. So far, she has led us ably by arriving at where we are. What needs to be done is to take it forward. And I am available. All the other heads of court are available. And as I said, I need not be a Deputy Chief Justice to support her on that. We have always committed ourselves. And the independence of the judiciary is something which is very close to my heart. And that I'm definitely thinking that it has to be, it's an imperative. Thank you.
Chief Justice, the question is partly answered. The first part was that in any two of the priorities, and the last part of it was, okay, what are the active or practical steps that you can take to demonstrate your support of those priorities?
Okay. We have already started to engage the executive. I'm part of a team that is negotiating with the executive. We're making proposals as to the engagement with the executive. What form should it take? What kind of institution do we want for the judiciary? The executive has got its own views on the kind of institution which differs from the concept that the judiciary has about the a fully institutionally independent executive. So already we've got the two teams, technical teams from the Department of Justice and the OCJ working together to identify those issues that would need attention. I hope that they will also come up with the costing thereof and transferring some of the functions to the OCJ, which were retained in terms of the memorandum which was entered into by the OCJ and the and the Department of Justice when the proclamation was passed to establish the Office of the Chief Justice as a national department. Those should have devolved immediately, but they were retained and there was a memorandum of understanding. Now we want all those things to be devolved to the judiciary. So there would be practical steps over a period to ensure that they are there. Visiting the courts, making sure that everything is available to ensure that access to justice is attained. Those are the nitty-gritties that we will have to work on. We have identified them. The conference was there. As I indicated, there are those other issues. All of them, I indicated that they provide a template for our trajectory as to realize this, the aspirations of the judges at that conference, how we'll deal with them.
JP, thank you so much. Thank you, Chief Justice.
Thank you.
Yes, Chief.
Thank you very much. Good afternoon, JP.
Good afternoon,
As
Commissioner.
a follow-up to that question, in your career, let me put it this way. It is well nigh irrefutable that we are coming or we're part of patriarchal society. And in the light of that, there are some concerns that are being raised where men must serve under a woman, as it will be the case if you are taken in as DJP.
DCJ.
DCJ, sorry. Now, as a follow-up, I wanted to ask you to clarify is that in your career, did you serve? We hear you that you have no problem about that, but are you able to demonstrate that? Did you serve under a woman, or did you demonstrate that you will have no problem in serving under a woman? Your leader.
Yes. The starting point, Commissioner, would be say, I hereby, as I do, undertake to serve under a woman. I am committed to serve. I have said I've pledged my support to the Chief Justice and all women leaders, not only in the judiciary, but in the society as a whole. I come from a background of of serving in organizations, and we're led by women.
I'm surprised that you have not mentioned thus far, including to your responses to Commissioner Shabangumdawe, that the empowerment of women is actually one of your fervent passions. And the fact
Yes.
that there is a majority of women in your division is not because the division is merely because the division has created conducive conditions for
Yes.
women to prosper there. It's through your personal efforts.
Yes.
And the fact that there's a number of women who are in the judiciary across the country today through your personal efforts. Don't be so modest, JP.
Sorry, Chief Justice. I just want to.
And
make a
at
follow-up.
Nadel, Chief Justice, we were led by women. I participated at the law societies of South Africa. There were committees which were led by women. I mean, one cannot divorce himself from that kind of situation. And I've never shown, and I challenge anyone, that I've had a problem being led by a woman. I've never had that.
I wanted to make a follow-up to Commissioner Soviet.
No, just one quick one on this one.
No,
On
are you following up?
No, mine is
on
not
this one, yeah.
on that.
Oh, all right.
So I'm happy to
Yeah.
defer to Commissioner Malema.
No. Mine is very simple. That who's leading you now, right in front of your eyes now, in the judiciary, and have you ever had a problem with that?
Not at all. And here are the capable women who are leading us.
Commissioner Ngaitu.
Sorry, JP, just on this point of the your priorities coinciding or promoting those of the Chief Justice, these two proposals, one, the judicial roadshows that you have in mind, and the translation of judgments into 11 official languages, are those the priorities of the Chief Justice? Because I've never heard her talking about those things. Or are those your own ideas? You know, because I think the public would be astonished that the Deputy Chief Justice is planning road shows. The public is expecting judges to be in court, hearing cases and delivering judgments. They are utterly frustrated when that is not happening. So I don't even know when these road shows will be taking place, when the expectation out there is that our judges must be doing the job they're employed for. Quite apart from the concerns I have about where the money is for these ideas. I'm not even sure that they coincide with what the Chief Justice wants to do. The Chief Justice has told us what her priorities are. It's to strengthen judicial independence. It is to create greater capacity in the Constitutional Court to enable it to do its job, and is to create more resources across the board for the judges to do their job. And I just have difficulties with these parallel proposals that you currently have. So I don't know if you want to persist with those proposals or where exactly we stand with them.
In answering
may
you,
I do
Commissioner,
something unusual and interpose before the candidate answers, but just in relation to one part of your question, Commissioner Ngqaito, about the translation of languages into 11 official languages. It is one of my priorities, actually, to promote indigenous languages. And just earlier this week, a day ago, I spoke at the University of Western Cape about, promoting the use of our indigenous languages, not just all official languages in the courts. And that is not so far removed from what the candidate has said about the judgments, because that would filter down to judgments, which I fervently believe should be in all our official languages, because they all deserve the same opportunity under the sun. I've answered that part for you,
Yes.
JP.
I may add,
you are on your own about
yes,
the
I may
road
add,
shows.
Chief Justice, that when you were interviewed, I see the light
Sorry?
is on.
No, I just wanted to know, I understood that he was saying every judgment that's been given must be translated into 11 official languages. Now, I understand the point that if you are in the Eastern Cape, you can have a judgment in Xhosa and in English. And in the same as if you are in Limpopo, having a judgment in Pedi and in English. I've never understood this radical proposal. In Sepedi, yes. Well, I've called it Xhosa, yeah. But I've never understood this radical proposal of every judgment in every language. And I have a real problem about whether it's been costed so that we can take it seriously.
Chief Justice, if yes,
Before
Chief
you
Justice,
answer,
when you were interviewed by this commission,
JP,
Oh, sorry.
President Mulemela would
Oh.
like to add to the follow-up before you answer.
oh, I'm sorry, my apologies.
Yes, thank you, Chief Justice. No, it's a follow-up in relation to the second part about the road shows. JP Tlaletse, you'll recall that when I posed the question to you about priorities, I said, what advice would you give to the Chief Justice in terms of what to prioritize in terms, given the competing priorities? It's because my understanding is that if you are a deputy, not only do you follow the vision of the leader of the court, but you are also entitled to give advice. You should feel free to give advice, and if it is accepted, well and good. If it is not, then that's the end of the story. Is that the correct understanding?
Someone will say it's a leading question, but I concur, accept. And President, I gave context to the roadshows. I said the administrative component of the judiciary should be the one that leads this process, supported by the judiciary. It's happening. I mean, I had students from high schools visiting me about last month, and we discussed all these problems. That's part of the roadshow. But on the issue of translation, the Chief Justice, when she was interviewed by this body, I think it's Professor Schlemmer, did put to her and commended her for having written a judgment in sqeaze. And related to that, she was concerned that Africans is going to be lost because of the policy that English be court of record, language of record. And she indicated that she will be happy to see all other languages being accorded equal status. And the Chief Justice said, thank you, that is one of the issues that we will take forward as the judiciary. And I am saying, with the development of technology, it should be easy to digitally translate some of these judgments and keep a record thereof. It's not something that can be done immediately now, given the fact that we do not have our full institutional independence. We will get together once we have that and make a priority of what we would need to do instantly. Thank you.
Okay, who came first? Minister.
No, thank you very much. JP Tlaletsi, I'm picking up on the issue on translation and your comment that we can utilize technology to be able to interpret. We know that development of indigenous languages in technology is not yet there. If we look at, because you are likely to have different interpretation of the words from English to Xitsonga, for example, or Shangan, or even the Sepedi part of it, or Chivenda. Now, if we are to say one of the areas as part of us being able to implement in the courts, it means we are still going to wait for many, many years, because I don't think the independence, as you assume, is going to take long. JP Tlaletsi, we just need legislation and you'll have your full independence. I'm committed, President is committed to that. But if you are to say to us here, with many South Africans, and I appreciate the issue of using languages for judgments, because it's about accessibility of our courts to the people. Being able to speak their languages, language is the most powerful tool for transformation. But if we say in that doing, where I have a bit of a challenge, and I say this as a person who's quite familiar with technology and artificial intelligence, the development of those areas, especially on our indigenous languages, is not yet there. So we'll have to utilize the physical people who are going to the current system that is going while you're developing the language itself in terms of those platforms. So I think the issue of being cognizant around the cost implication, because I don't think even when we talk about the issue of the judiciary being independent, we've vetted the issue of the availability of resources within the state, within the country, for all of us, because we're going to take money from the same pot. So I thought I should just make that comment in terms of that area. Thank you.
Thank you, Minister, for that. As I said, it's a long-term goal that we ultimately need to see if we can strive, given the resources that we might get at the time and the assistance that we might get from institutions that deal with technology and development of artificial intelligence. One other thing, Minister, that I was thinking also, it's if you could have some dedicated channel to mainstream the judgments, the cases in the Constitutional Court, and perhaps some important ones in the Supreme Court of Appeal, so that people can see, justice at work in the comfort of their homes. That can assist and not only be limited to YouTubes. We have the parliamentary channel. I think most people start to see what's happening in Parliament in a channel like that. I was just thinking also that as part of conscientizing people, reaching out to people, that you could have something like that. I know it will be costly, as some say. I don't know how costly it would be, but some things are imperative, they need to be done. And we can sacrifice a few of the things that we need to do that are not extremely necessary to attend to that. Thank you.
No, agreed. I know CJ and team are working on it, on the streaming of the Concord.
Commissioner Pillay?
Thank you. It's a follow-up. Thank you.
You may ask your questions though.
Thank you, Chief Justice. Good afternoon, JP Tlaletsi.
Good afternoon, Commissioner.
JP, in the course of this afternoon, you've repeatedly used the term full institutional independence for the judiciary. And earlier when you presented your vision, you lamented the fact that the judiciary is accountable to National Treasury for its budget and subject to budget cuts
by National Treasury. Now, my question is really in two parts. The first is, do you believe that full institutional independence is possible? And if so, what checks and balances do you propose in relation to the judiciary's handling of public funds?
Yes. Well, thank you, Commissioner. I would call it full institutional independence, in the sense that the judiciary will be running its own affairs. The judiciary will be part of the arms of state that get money from the treasury. And then there should be systems in place within the judiciary how to employ those finances. There has to be, and I did indicate that, an urgent matter that we may have to consider. How are we going to account with the kind of monies, the monies that you are going to get? Currently, we have the Secretary General going to the Portfolio Committee to make an explanation there. But this thing has been a sticking point because the parliamentarians go beyond at times, and rightly so because it involves money, to ask about the activities of the judiciary. And it created problems, as if now the judiciary is accounting to the Portfolio Committee, to the politicians, something that some members of the society also frowned upon it. But there has to be a structure. Let's say if we take the current model that we are thinking about, that we are going to have a judicial council and an advisory body. That council should have a system of accounting to the treasury on the appropriation that we would have received. And it should not only be enough only for what we call Judiciary Day and invite Portfolio Committee members to listen to what we say and produce reports. We want to see full accountability and make sure that everybody understands that we are functioning within the parameters of the state as an independent arm of state. Issues of employees within the judiciary, those are the issues that will need to be taken into. I don't think personally it would make sense have our support staff reporting to public service, to the Department of Public Service. I mean, they have their own priorities, and that creates problems now between the judges and the employees. At the moment, I know you know this very well, Commissioner, that they fall under the ministry, and their loyalty in terms of the prescripts of the public service and the act. The reality first is the minister, and we are being consulted. And this has been a problem. But I assure you, we have to have a meaningful way of accounting to as an arm of state. The Judicial Council and the CEO, if we have some person like that, or whatever we call ASG, the Secretary General, should be the one who present that. I would not want to see a situation where the Chief Justice go to this organization, to the arms of state and account to them and being asked questions. Thank you.
But in your scheme, JP, you retain National Treasury's role as the custodian of the budget.
Definitely, that is the entry point of all the monies, and this is where we are going to get the monies from. And even if we were to get funds and whatever from other sources, we have to disclose them to the Treasury, and the Treasury must make a record of those to ensure that there is transparency. Thank you.
Thank you, JP. Now, just in relation to the answers you gave Commissioner Shabangu Ndawe earlier around the role of women, and I take note of the CJ's remarks about the role you've played in advancing women in your division. I was making a careful note of your answers around what is needed to advance women in the legal profession. And I'm a bit concerned about your direction, and I'll tell you why. You raised 5 issues. You say there must be better education at universities. You said once they're in a profession, women must be trained to move forward. You said that women must be given opportunities within the profession. You said that they must be given opportunities to act. And you said that conditions should be made easier in order to accommodate women. The difficulty with all 5 arguments or points that you raise is that it places the spotlight on women and seems to assume an inadequacy in the woman. What you don't touch on is the systemic barriers to the advancement of women.
Yes.
Now, I just wanted to find out, to your mind, what are those systemic barriers to the advancement of women in the profession?
Yes. Actually, for me to catalog those issues was relating to systemic barriers that women face. I did indicate that in addition to their, for example, practicing as lawyers, they do have other challenges that they have to face because they are women and they are running families and all that. So we have to make sure that we accommodate them. There's provision for that. And within the structures of the of the profession, there should not be any barriers that makes it impossible for them to advance. Not that they must get special attention. They are fully aware, they are fully adequate, and you have seen the results that they are doing well. And even when they appear in our course, we'll see that they put a lot of weight and they influence most of our decisions. So I was just thinking of those things that one would find in the profession that would make it impossible for them to stay on and to advance their careers within the profession.
Do you believe that women lawyers and or women judges operate in an environment that's inherently hostile to them?
It depends where one finds himself or herself. If I take the let's say advocacy, the kind of work that is dished out to practitioners, it's not always that you find that women benefit from that private and business work. Mostly, they will get work from the state attorney. That is from where I've realized where I preside. Maybe some RAF matters, a few, but mostly the briefing patterns makes the environment hostile.
So JB Tlaletia, that's precisely what I'm driving at. Do you know why that's the case? Why aren't women getting the commercial work? Why are women forced to depend on state attorney work and RAF work?
I think it's a question of acceptability by those who are already there. There's some of the excuses that they would give it, say, my client wants me to do this. This is the instruction from the client, which I believe, you have to advise your client as to what is the policy of the profession and how you should also conduct your practice. So, but the environment at times, it's such that it makes it impossible for them to continue.
And speaking of a hostile environment, do you believe sexual harassment within the judiciary is an issue?
I wouldn't say it's an issue that I have identified as a problem. I am aware of an instance that has gone public with those allegations, but I am not aware of, or I could say it is a problem as such. But one should not rest on saying it's not a problem because there could be those that we are not even aware of. So having a anti-sexual harassment policy will assist to open up and make us aware that there is this problem. They might be kept secret. There might be those instances, it might be difficult to know that they exist, they are happening. And obviously, if they are happening, then they will get reported. If I'm a head of court and I come across that problem, I will take it up immediately.
Chief Justice, it's just the last follow-up and then I'm done. Just in relation to the so-called anti-sexual harassment policy, I just want to understand, firstly, you've been asked exhaustively today how you align with the priorities of the Chief Justice. What you've just indicated now, do you believe that aligns with the priorities of the Chief Justice on sexual harassment? That's the first question. The second one on the so-called anti-sexual harassment policy, have you considered the policy and do you believe it addresses all the specific characteristics of the judiciary which makes sexual harassment an issue within the judiciary?
Yes. I aligned with the policy, the priority of the Chief Justice. This comes a long way. I was part of the heads of court when it started, and there was an attempt to have one, but it was held back and said it needs to be formally and professionally be prepared so that it can cover everything. We have looked at it. I personally looked at it, and I do not have a problem with it. There were only a minor issue, I think, that I looked at, which I had requested that the committee should look into, or the preparatory committee, where it extends over to the employees. It is a judiciary policy, but currently, as we stand, we still have the employees who are going to be covered by it, which might conflict with the policies that they have in the public service. So those, and we do not know whether those policies or their actually policy do cater for what is already contained, but it was just to compare. But within the judiciary, I know there were other issues that were raised, but I do not have a problem there with. And I don't have a problem. And I fully support it, I must say.
Sorry, Chief
Follow up,
Justice,
CJ.
I need to really follow up on this one. So, the difficulty, sorry JP, I know you are drinking water there. I'm not interrupting your need to drink water. But I think there may be a misunderstanding of what your answer is on the sexual harassment question. Remember that the question was, do you believe that sexual harassment is an issue in the judiciary? And then you said, I wouldn't say it is an issue. Now, I have a real problem with that answer, and I believe that you may have miscommunicated. Everyone sitting here interviewing you believes that sexual harassment is an issue in the judiciary, and that it must be uprooted, and that it is pervasive, but it is unreported, and it's unidentified because victims are afraid to come out because the structure of the judiciary is patriarchal.
Yes.
That's what everybody here believes. You're the only one in this room who believes it's not an issue.
Well,
can you just clarify your answer on that issue so that we don't come out with a wrong impression?
Yeah, I indicated that.
Perhaps before you answer that question, JP, let me add to Commissioner Ngukaitobi's question.
Yes.
Your division, the draft sexual harassment policy doing the rounds received overwhelming support from the entire judiciary, bar one division, your division. Yes, your division is one of the few among us who came up with useful, substantive issues for further considerations, which is what we are busy with now. But then its final word was that there actually is no need for the policy because we have the Code of Judicial Conduct, which is adequate to deal with these issues. And of course, it was a joint report of the division, not written by you, but by a senior woman judge in your division. But one assumes that you were part of that view. And I want to, as you answer Commissioner Ngukaitobi's follow-up question, to assure me, to assure us and everybody else concerned,
yes,
that you really support this document and believe that there is need for it.
Definitely, Chief Justice, I support, and I did indicate, and I do also say I support it. And as I say, it's just a question of having to compare with the public service, how it extends to the administrative staff. On whether it is an issue, my answer is based on the fact that I cannot say it's not there. It could be there, but it's not in the open. But if I were to come across any of such an incident, I am bound to immediately raise it and not allow it to lie there and not be attended to. Up to now, I have never come across an issue which I have known about sexual harassment that I would have had to disclose or be even a complainant about it. But if the scourge is there, I accept it, but I have not come across a case like that. If it exists, obviously it should be an issue, but the problem is the incidents that I was not aware of. And if the members of the House say it is there, it means then there will have to be further investigations to make sure that it's rooted out and not only allow the victims to come up and create an environment that it is being addressed. Thank you.
Commissioner Baloy?
Follow up, CJ.
Thank you. Good afternoon, JP. Yes, JP, this what you've just said now, that in fact, I think a few comments earlier even, that you're not aware of that it is a problem, sexual harassment in the judiciary, is concerning if it suggests, and that's what it seems to suggest, that there is in fact no discussion within the judiciary about what has been identified, but for your division, that has been identified as a problem in the judiciary. I mean, as Commissioner Ngqokeitobi says, that everyone in this room knows that there is a concern about sexual harassment in the judiciary and that it is pervasive or it is a real problem. And if you say, well, I'm not aware of it, it's worrying because because then it suggests conversations are not happening in the judiciary. They may be happening in silos if they are happening, but if you're not aware of it and you're not part of those conversations, then it's a completely different worry that we should have.
Yes.
Is it a fair reflection that there's no conversation in the judiciary about this?
Commissioner, thank you, Commissioner. I would say in my division, we haven't had such a problem that I had to deal with, especially in the High Court. I do not recall being party to a conversation, say at national level, that you have this sketch and that it need to be attended to. We all accept that if it is there, and we know it's difficult for it to come out. But I personally would say I have not had intimate discussions relating to it that much. My recollection.
Can I just
Thank you, CJ.
just a follow up on this?
Minister.
JP Tlaletse, what
Yes,
is your understanding of why the CJ, as one of the things that she has put as a priority? I think in every meeting that I meet her, for example, I know there's no way that meeting will finish without her talking about the gender desk and the issue of sexual harassment police. I know for a fact. Actually, I panic when I go to her if I don't have answers around that area of work. Now, with your response, what is your understanding of her being so much putting pressure on this issue that led to yourself as part of the heads of courts that sits with the CJ as the leadership of the judiciary, not being able to pick up this issue as something that you must open conversation in your division?
Yes. In the first place, there was no policy at all. If there was a complaint like that, it would go the normal route of the JP or directly to the JSC. But that lack of policy being in place did not necessarily mean that it is not there. So one of the objectives of the policy, I think, is to make for everybody within the judiciary to be aware and not to sit with problems. They should come up. But what I was saying is that policy has certain definitions of things that people would not have thought that they would amount to sexual harassment. But being part of the society in South Africa, I mean, you would get a situation where there is sexual harassment. But I was merely saying I've never put my finger on any of such conduct within the judiciary where I serve. Thank you.
No, thank you very much, Chief Justice. JP,
Ma'am.
it's not about you coming across sexual harassment. What we want to know, what is your conviction, your views about it? You seem to come across as someone who's holding back his views, and that does not assist us seated here. So up until now, you've left us confused on a number of issues. So please explain yourself. What are your views about sexual harassment in the work environment?
Commissioner, I abhor it. I don't like it. I dislike it. Wherever I see it, I will report it and I will deal with it. It's something that I will never support personally or even in my professional capacity. If I created any impression that maybe I will tolerate it, I would never, definitely. Thank you.
Commissioner Hassan?
Thank you very much, CJ. JP, I'm also going to ask this by way of follow-up related to the sexual harassment policy, but I'm going to craft it a little bit differently. Look, JP, the Deputy Chief Justice plays an important role in supporting the Chief Justice, not only in terms of judicial leadership, but also helping drive institutional reform. And one of the CJ's stated priorities, and I think Minister also mentioned it now, is the finalization and the implementation of a clear and credible sexual harassment policy for the entirety of the judiciary. So the question is, what are your views on the role that policy should play in preventing and addressing sexual harassment in the judiciary? And how would you see yourself supporting the Chief Justice in ensuring that this policy becomes an effective and enforceable tool for change? Thank you.
Thank you. Already with the current process, everybody in the judiciary is aware that there's a process of having this policy finalized and to be put in place. Once it is in place, it is the responsibility of every judge to start with, irrespective of the position, whether as leadership position or not, to ensure that this policy is implemented. It is well understood, it is known. If I am appointed and it is one of the matters that specifically the Chief Justice assigned to me, I will run with that still and make sure that well understood, it's being implemented, and there's no case that goes unattended to and unpunished. Even if I'm not the Deputy Chief Justice, I still commit myself that I will deal with that issue of sexual harassment in whatever form. The good thing is the policy itself, once finalized, it will explain how sexual harassment manifests itself. And that's why victims do not readily come out to report this kind of harassment. And it will be a conduct and a standard that each judicial officer should live by for all levels of the judiciary, from the judges, president, let's say from the constitutional court up to the lowest court in the magistracy, including the land claims courts.
Commissioner Malema?
Thank you.
I didn't want to get involved, but I realized I must just try and help the situation. Is there a sexual harassment problem at workplaces in South Africa?
Is that the
Yes.
question?
Yes. I'm
Well,
asking.
yes.
Is-
From my experience, starting from the labor court, there has been that problem that has been identified.
So judiciary is a workplace.
I don't know, do we need a dialogue, Chief Justice?
Don't do that because we're trying to find your view on this matter. I'm not engaged in a dialogue with you, JP. I'm trying to arrive at a certain point. Why? Because you are making it difficult to make up our mind in relation to your thinking on this matter. That's why I'm coming up with a different approach. I asked, is there a problem of sexual harassment in society? You said yes.
Yes.
Is judiciary not a working place?
It is.
Therefore, it means there will be a problem of sexual harassment in the judiciary because there is generally a problem of sexual harassment in society.
Yes.
Now that you came before us to apply for a position where you are going to support the Chief Justice and you are confessing that you didn't know that there is a problem of sexual harassment in the judiciary, now you know.
What I'm saying, Commissioner, is the actual cases in my workplace, I have not come across that. But I do not rule out that they are there. I'm saying without a policy, it will be difficult to get to know about these cases. Once there is a policy in place, it will encourage everybody to make it known so that we have this scourge and then address it immediately.
No, JP, you are applying to go and assist the CJ. Assist her on what? Because you don't know what are the issues there, what are the problems. I'm saying, with all of everybody's input now, not your experience, where you work and all of that, now at a national level, with national consciousness that is given to you now, out of this input, do you accept that there is a sexual harassment problem in judiciary in the same way there is a problem of sexual harassment in society? You might have came here not aware, but with everybody's input now, do you now accept that it looks like there is a problem the judiciary is dealing with? You were not aware of it. You are now aware of it. But it makes it problematic for me to want to go and help the CJ on matters that you don't know. Help her on what? Because you don't know there is a problem she's dealing with.
Yes.
That's why she's trying to expedite the issue of sexual harassment policy, which you are aware of. And when it became an issue, a judge with interest in leadership position would have inquired as to what necessitates such a policy. Because we've been operating here, there was no policy. Why now? Because you have got interest in leadership position. Being Deputy Chief Justice is a leadership role and is to help the Chief Justice, and you are going to help her on issues that you are not aware. What are the issues? Now you know, you do accept that there is a problem of sexual harassment in the judiciary with all inputs given here.
I have been assured that there is that problem, and I do accept that there is that problem. What I was trying to put forward was that I personally have not come across a specific case that I had to deal with. But if the scourge is there, I do accept.
CJ, I personally never came across a case of racism, but I know there is racism.
Are there any further questions for the candidate, colleagues? Inkos.
Thank you, CJ. Good afternoon again, JP.
One more time, good afternoon, Commissioner.
Can I be protected from my left? Sorry, Chair. South Africa is composed of different and diverse nations. with different cultural norms and values, as you know,
I just missed the last word, different.
norms and cultural norms and values,
Yes, yes.
as you know. In fact, it is a mirror of United Nations, but the Constitutional Court, therefore, is a mirror of International Court of Justice, but with a different, because this ICJ of ours is binding on all of us in South Africa. No one can ever defy it. Now, there are two legal systems in our country: the Roman Dutch legal system, and as well as the indigenous cultural, customary legal system on the other hand, and the need for both to be treated equally, as you know, in terms of the Constitution. And now, how are you going to be able to deal with this issue if you are accepted and taken as the Deputy Chief Justice in dispensing justice, assuming that there may be, of course, a case involving parties, either the Roman Dutch on the other hand, or customary law on the other hand? And how are you going to be able to deal with that? In other words, what I'm trying to test from you, I know what you're capable of, but I would like to know more whether you are capable of handling the complex issues that are within the customary indigenous legal system.
If I may understand, it being a case that has elements of customary law or indigenous system and so-called civil law. I just wanted to make sure I understand the question, Commissioner.
Oh, thank you. Through you, Chief Justice. Yes. All I want to know is to whether you are sensitive or capable of understanding the dynamics involved in terms of promoting this dual legal system. The Roman Dutch system, on the other hand, as well as, on the other hand, the customary one, indigenous law. Right. In terms of the Constitution, I think you know that they must be treated equally, but both are subject to the Constitution of the country. That's all I want to test from you, whether you understand those dynamics, and if so, will you be able then to dispense justice? But I want you to concentrate on the other side, not the Roman Dutch legal other side, on the customary side. That's what I wanted to test your knowledge there.
Yes. No, Commissioner, definitely our society and the majority come from the traditional, we can call them the traditional society, and they have been regulating their lives in terms of the traditional norms, customary rules and beliefs. And obviously, if I have a case like that, I will be in a position to identify the actual problem and look at the parties, and surely if they subscribe to that, make sure that it assists in resolving the problem. If you consider one of the judgments that I wrote, Kivis Kroon, Country Estate versus Moledi, it was an employee who was dismissed. She was a chef, only because she had to undergo a process of twasa. And the employer said, look, whatever you are going through is not an illness to us. You don't comply, and she was dismissed. And I managed, when I dealt with the case, to identify the beliefs that she had and the system, cultural, traditional beliefs that she went through and that she was going through, and found that dismissal to have been substantially and procedurally unfair, and ordered her to be reinstated. The Supreme Court of Appeal agreed with me and endorsed that judgment. So they have to play a role. And actually, that kind of system, particularly when you come to these areas where it applies, it has built in it a form of mediation, and it quickly resolves problems that exist within the society. More so that people subscribe and believe in that system. You actually do not need someone sophisticated, educated in this kind of other law to be able to practice that. On its own, it can be a self-standing system that regulate the lives of the society in that area.
Is it to you, CJ? Incidental to that answer, what's your view on the role of traditional courts in dispensing justice in South Africa?
To buttress what I've said, they play a very good role, a very meaningful role, and they are part of our court system. And we should encourage dispute that can be resolved at that level, to be in that fora, to be resolved at that level. Unfortunately, because of the subscription to the norms and traditional values, people subscribe to them and they do not create a problem at all. And people continue with their lives.
Thank you, CJ.
Thank you.
Thank you, CJ. Good evening,
Good evening,
JP Tlaleti.
That time already. Thank you, Commissioner.
Mine flows from a point that you made earlier when you were making a presentation with regards to the need to relax rules as part of your plan to ensure expeditious conclusion of matters, but also to ensure access to justice. The decolonization of the law project, which remains a stubborn elephant in the room, despite debates at various levels, to really deal with this question of decolonization of the law, there seems to be lack of political will, lack of appetite, and such that the project has not really gained much traction. What would be your role as the DCJ in ensuring that this project gains that momentum and that we begin to make meaningful inroads in ensuring that we dismantle the colonial legal system? Thank you.
Yes. Thank you, Commissioner. I personally believe that there are certain of these systems which may not necessarily be suited to our conditions. And those that do not advance the relations between citizens can be done away with. If it becomes one of the assignments given to me by the Chief Justice, I will get the stakeholders and start a debate and take it further as to how we can embark on the process of decolonization of the law. It's a welcome project that I think we need to embark upon.
Thank you, CJ.
It does not appear that there are any further questions for you, Judge President, so we have reached the end of the proceedings. Thank you for accepting the President's nomination for this vacancy. We appreciate it. I know you were not particularly keen to accept it, but then you made yourself available. And thank you for bearing with us. Is there anything you want to raise with us before I release you?
Well, to thank the commissioners and the commission for the discussions that we had, and I think they are very fruitful and they will take the judiciary forward. And I enjoyed them, I must say. The length of time we spent together in here can only be something that we all learn from it. And once again, thank you for this opportunity, for this invitation. Convey my appreciation also if the result does not come my way, that I appreciate the confidence that the president has had in me by making me part of this process to enable him to decide who would be the deputy chief justice. As I said, I don't feel that I am entitled to it. There are other people who could be in a position to be given this opportunity. We are equally, differently empowered for this position. I thank you very much.
Thank you, JP. Go. That's the end of our day, colleagues. Just for how did we do it? That's magnificent, all right.
Did we catch up with time?
We did. We did. Okay, we'll meet tomorrow at 9 a.m., colleagues. Thank you.
Give us a great afternoon.